All right, party peoples of the interwebs, I had my vision. I was going to go bicycling on the Everglades Canal, stop under a tree, do a wonderful law vlog, and instead, this is what happened to me. All right, I'm bike riding on the Everglades here, and if you look in the distance, you see something that kind of looks like smoke. That's not smoke. Those are gnats. Clouds of gnats. All of these things on my arm, gnats. Look at this. I'm gonna puke. They're in my eyeballs. They're in my eyeball. I don't know if you get, they're in my eyes. Everywhere. I thought it was smoke. Do you see that? Let me zoom in all the way. Those are clouds of gnats. That is not smoke. And I feel sick. This was a bad idea. Look at my legs. Look at my legs. Okay, well, unfortunately, I gotta go back through it to go home. So now that I've taken a thorough shower, brushed my hair thoroughly, applied the argan oil, I am ready to do the vlog that I wanted to do on the road or on the canal. And it's a great decision coming from the 9th Circuit out of the west coast of the Americas, and it relates to COVID. Now, the procedural posture of this case is relatively interesting, and also the chicanery pulled by the Los Angeles United School District, the LAUSD. But first, just to summarize the procedural posture, and that is fancy legal talk for the state of the file. The panel vacated the district court's order dismissing plaintiff's action alleging that the COVID-19 vaccination policy of the Los Angeles United School District, LAUSD, which until 12 days after oral argument required employees to get the COVID-19 vaccination or lose their jobs, interfered with their fundamental right to refuse medical treatment. So more simply put, a panel of the Court of Appeal at the 9th Circuit vacated the initial judgment dismissing the plaintiff's claim that the COVID-19 vaccination policy, and I'll put it in quotes for a damn good reason, violated their rights. The lower court dismissed the plaintiff's claim. The panel vacated the lower court's decision to dismiss the plaintiff's claim, and here the Court of Appeals 2-1 reversed the lower court's decision and send this back to the lower courts for further consideration. Now, some outlets are running with the sensationalist headlines that the 9th Circuit Court of Appeals declares that the COVID-19 jab is not a traditional vaccine, and that is not exactly true. But what they've declared is that at this stage of the proceedings, the plaintiffs have alleged that the COVID-19 jab is not a traditional vaccine, such that Jacobson, that precedent, that horrible precedent in Jacobson, does not apply to their case, such that their case cannot be dismissed on the basis of Jacobson, because in Jacobson, we were actually dealing with a traditional vaccine that actually prevented the contraction and transmission of a virus. Whereas in this case, we're not dealing with a vaccine that does that. We're only dealing with something closer to a therapeutic, and therefore this is not a traditional vaccine. Therefore, Jacobson does not apply. That is the argument raised by the plaintiffs, which cannot be dismissed at this stage of the proceedings. That, and the Court of Appeal has some choice words for the Los Angeles United School District, who was playing some serious dirty chicanery with the policy that they put into effect, that they then suspended or modified when they got sued, that they then put back into effect when the lawsuit was dismissed, and we'll get there in a second because it's dirty. Opinion R. Nelson, Circuit Judge. For over 2 years, until 12 days after argument, Los Angeles Unified School District, LAUSD, required employees to get the COVID-19 vaccination or lose their jobs. LAUSD has not carried its, quote, formidable burden, end quote, to show that it did not abandon this policy because of litigation, and thus that, quote, no reasonable expectation remains that it will return to its old ways, end quote. So this case is not moot. On the merits, the district court misapplied the Supreme Court's decision in Jacobson versus Massachusetts, stretching it beyond its public health rationale. We vacate the district court's order dismissing this claim and remand for further proceedings under the correct legal standard. So here, as you can see, the LAUSD basically argued that the issue was moot because they ended their policy of mandatory vaccination, and the court says you have been playing games throughout this entire context. When you got sued, you modified your mandate, and then when they abandoned the suit, you then reinstated your mandate. You then again got sued, and 12 days after argument, you discontinued your policy and then argued that the case was moot and that it should be dismissed. And the Court of Appeal says you are playing serious screwy games, and we no longer believe that you're not going to re-implement this policy, so it's not moot, and you've been screwing around, and we're giving you a little bit of a judicial spanking. This case is about LAUSD's COVID-19 vaccination policy. LAUSD has reversed course several times. Because of its importance to the mootness issue, we recount that history in detail. LAUSD issued its first policy on March 4, 2021. That policy was challenged 2 weeks later in a lawsuit filed by plaintiff California Educators for Medical Freedom, CEMF, and several individual plaintiffs. According to CEMF's complaint, LAUSD's policy required employees to get the COVID-19 vaccine, no exceptions. The March 4 memorandum announcing this policy was attached to the complaint. So the LAUSD implements this COVID-19 vaccination policy, no exceptions. They get sued, and then they issue a clarifying memorandum which provides for some exceptions. The very next day after CEMF filed suit, LAUSD reversed course and issued a, quote, clarifying memorandum, end quote, that gave employees an option to test for COVID-19 if they did not want to get the vaccine. Relying on this clarifying memorandum, which LAUSD claimed did not impose, quote, mandatory vaccinations, end quote, LAUSD moved to dismiss CEMF's suit because, among other things, it was, quote, moot and or premature, end quote. LAUSD disputed whether CEMF had adequately pleaded that exemptions would not be allowed. LAUSD played this game of judicial whack-a-mole where they would implement the policy, then create an exception to it, then eliminate that exception, then get sued again. And basically the Court of Appeal says, you've been screwing around a little bit too much. We no longer trust you. You no longer have displayed good faith in the manner in which you seem to be dodging litigation. So this is not moot. We're going to send it back to the lower court for remand so they can adjudicate on this. It is certainly not moot because you have displayed bad faith in the context of this litigation. And now let's get to the substance of what the higher court, Ninth Circuit, decided as relates to the applicability of Jacobson. Now, if Jacobson sounds familiar to you, it is only because it goes down in history as the holy trinity of the most awful Supreme Court decisions ever issued. The other two are Buck and Korematsu. Buck was the one that authorized the sterilization of idiots, unintelligent people, or people with IQs sufficiently low that they should not breed. It was nothing shy of eugenics authorized by the Supreme Court of the United States of America. The Korematsu decision was the decision that argued or concluded that you could intern Japanese Americans on the basis that they posed something of an existential threat to America. Jacobson was the decision that people argue authorizes mandatory vaccination, except for the fact that even in Jacobson, it never authorized mandatory vaccination. It just authorized the issuance of a small fine in the event that someone didn't want to get vaccinated, a vaccine that actually worked in the context of smallpox. And it's that caveat of a vaccine that actually worked, a traditional vaccine that actually yielded results by way of preventing transmission or contraction of an illness that is going to be at issue here. In Jacobson, the court comes to the conclusion that the vaccine actually worked and there could have been some rational basis for implementing the policy. But in this case, the plaintiffs are alleging that the so-called vaccine, the COVID jab, doesn't even prevent transmitting or contracting the virus. Therefore, it's not a traditional vaccine under the sense of Jacobson. Thus, Jacobson doesn't apply to dismiss their case. At page 10, plaintiffs argue that the COVID-19 vaccine is a, quote, medical treatment, end quote, and not a traditional vaccine. The district court disagreed, holding that, quote, Jacobson does not require that a vaccine have the specific purpose of preventing disease, end quote. Later on, a little bit more of the judicial spanking. Litigants who have already demonstrated their willingness to tactically manipulate the federal courts in this way should not be given any benefit of the doubt. LAUSD's about-face occurred only after vigorous questioning at argument in this court, which suggests that it was motivated, at least in part, by litigation tactics. For example, in Columbia Basin College, we upheld a finding that the voluntary cessation mootness burden had not been met. We were persuaded by the district court, which noted the defendant's strategic timing of sending a letter purporting to moot the case more than 3 years after litigation, but only 1 month before moving on mootness. Here, too, LAUSD's timing is suspect.
Let me tell you something. You're suspect.
And now back to Jacobson, and just always bear in mind, this decision does not declare as a matter of judicial fact that the COVID jab is not a traditional vaccine. What it concludes is that plaintiffs have alleged it is not a traditional vaccine, such that their claim cannot be dismissed on the basis of Jacobson, which was issued in the context of a traditional vaccine, you know, the vaccines that actually worked at preventing, contracting, and transmitting an illness. The district court relied on Jacobson to hold that the policy was rooted in a legitimate government interest. But Jacobson does not directly control based on plaintiffs' allegations. In Jacobson, the Supreme Court balanced an individual's liberty interest in declining an unwanted smallpox vaccine against the state's interest in preventing disease. The court explained that the, quote, principle of vaccination, end quote, is, quote, to prevent the spread of smallpox, end quote. Because of this, the court concluded that the state's interest superseded Jacob's liberty interest, and the vaccine requirement was constitutional. Plaintiffs argue that a, quote, traditional vaccine, end quote, must provide immunity and prevent transmission, meaning that it must, quote, prevent the spread, end quote, of COVID-19. Plaintiffs allege that the vaccine does not effectively prevent spread, but only mitigates symptoms for the recipient. And plaintiffs claim that something that only does the latter, but not the former, is like a medical treatment, not a, quote, traditional, end quote, vaccine. This interpretation distinguishes Jacobson, thus presenting a different government interest. What the plaintiffs are basically alleging here that the COVID-19 vaccine, the jab, is not a traditional vaccine. It doesn't prevent contracting the illness or transmitting the illness, such that it is only at best a therapeutic, like in the way that certain public health officers like, Kieran Moore, the chief medical officer out of Ontario, refer to the COVID-19 jab as a therapeutic.
There's always a risk to having any therapeutic, therapeutic versus a benefit. You want to make sure there's a very strong benefit versus the risk.
If you've established that the COVID-19 jab is actually not a vaccine but a therapeutic, can you then have mandates for therapeutics such that the Jacobson decision applies? And this court comes to the decision that we don't judge on the merits yet, but at this stage of the proceedings, taking for granted what plaintiffs are alleging, Jacobson does not apply because they're arguing that this is a therapeutic such that Jacobson does not apply to this case. At this stage, we must accept plaintiff's allegation that the vaccine does not prevent the spread of COVID-19 as true. And because of this, Jacobson does not apply. LAUSD cannot get around this standard by stating that plaintiff's allegations are wrong, nor can LAUSD do so by providing facts that do not contradict plaintiff's allegations. It is true that we, quote, need not accept as true allegations that contradict matters properly subject to judicial notice, end quote. But even if the materials offered by LAUSD are subject to judicial notice, they do not support rejecting plaintiff's allegations. LAUSD only provides a CDC publication that says, quote, COVID-19 vaccines are safe and effective, end quote. But, quote, safe and effective, end quote, for what? LAUSD implies that it is for preventing transmission of COVID-19, but does not adduce judicially noticeable facts that prove this. And going back to what I said at the beginning of this vlog, the court again reiterates that they are not issuing any determination on the merits. They are not declaring that the COVID-19 jab is not a traditional vaccine as a pure matter of fact, although I think we all bloody well know that by now. What they're saying is that you have to take the plaintiff's allegations for true, such that it is premature to dismiss the claim now and it has to go back for further review, and the court says as much. We note the preliminary nature of our holding. We do not prejudge whether on a more developed factual record plaintiff's allegation will prove true, but, quote, whether an action can be dismissed on the pleadings depends on what the pleadings say. Because we thus must accept them as true, plaintiffs have plausibly alleged that the COVID-19 vaccine does not effectively, quote, prevent the spread, end quote, of COVID-19. Thus, Jacobson does not apply, and so we vacate the district court's order of dismissal and remand. And that's the decision. It's a very good decision, and I have no doubt that it is going to be proven that the COVID-19 jab does not prevent the transmission or contraction of COVID-19, because it doesn't, because that woman out of Europe basically confirmed when asked a question that they never even tested the jab as to whether or not it prevents transmission because they were moving at the speed of science. So I have no doubt the plaintiffs are going to succeed in proving that aspect of their claim, and in which case Jacobson will not apply to these bloody claims, and it's about bloody time that some courts have the judicial cojones to finally say enough is enough, and no, you're not going to get to justify everything based on one of the three evil decisions coming from SCOTUS, because alas, that one does not apply to a vaccine that does not prevent contracting or transmitting a virus. So we will see where this goes. We will discuss this during our Sunday show with Robert Barnes, but if you like what I do, you know what to do. Make sure that you are subscribed and you have notifications turned on. I think a very low percentage of subscribers have notifications turned on, so you don't know when I put out a video, but when you see a video of mine come out, give it a like, give it a thumbs up, drop a comment, and if you don't like it, give it a thumbs down and let me know why you don't like it. But most importantly, you can find me on Twitter, the Viva Frei, Viva Frei on Rumble, vivabarneslaw.locals.com. But alas, really, most importantly, exercise, eat healthy, get outside, sunlight, avoid the gnats, talk to people in real life, and now you know you vlog. Peace out, peeps. Booyah!
Regarding the question around, did we know about stopping humanisation before it's entered the market? No. We had to really move at the speed of science to really understand what is taking place in the market. And from that point of view, we had to do everything at risk.